Okay, hi, a very good afternoon to everybody. And today we are going to complete the other part of CRPC. So we are doing a rapid revision. I request everybody to open their barracks and we quickly move on to section 106. Now, when we speak of section 106 here, this is talking about the security which is required for keeping the good behavior. So under this chapter, which is chapter 8, section 106 is very important, and this talks about a bond which is going to be for 3 years. So section 106, speaking of security for keeping the peace on conviction, the time period is not exceeding 3 years. And on the other hand, one important question for your prelims is section 110, which also says that the time period shall not exceed 3 years. Meaning thereby, section 106 and section 110, which deals with habitual offenders, in both the cases, the time period is going to be not exceeding 3 years. And in the other sections, the time period is 1 year. On this point, everybody, we move on to section 125. Now, from section 125 onwards, in this particular chapter, which deals with the maintenance, this is a very important chapter for your prelims. And section 125 talks about the order for the maintenance of wife, children, and parents. Here, the maintenance order is given to the wife. It is given to the legitimate or illegitimate minor children. It can be a legitimate, illegitimate minor child, whether married or not married. And here it can be a father or mother also. A living in partner is not included under section 125. Father, mother, son, husband, everybody is liable to give maintenance here. On this point, the landmark judgment is Muhammad Ahmed Khan versus Shah Banu, and the overriding jurisdiction was given in the case of Rajneesh versus Neha. Now, if you come to section 125, subsection 4, the refusal grounds are there. We have adultery. There should be no sufficient cause for living separately, and then you are living separately with mutual consent. Moving on, when you have to speak about the cancellation of maintenance, we have section 125, subsection 5, section 127, subsection 2, and also section 127, subsection 3. If the woman she remarries, her order for maintenance will be held, it will be cancelled, it will be revoked. Coming to section 129, everybody. When we speak of section 129, in this particular chapter, which is chapter 10, here section 133 is very important for your prelims. It deals with the additional order for the removal of nuisance. Here, who has the power is very important. It is the DM, it is the SDM, it can be any other executive magistrate. Now, on this point, we come to section 144. So 133 is important. Section 144 is very important. Section 144 talks about power to issue order in the cases of nuisance. Here, the power has been given to the DM, to the SDM, or to the EM. This is a very important question again for your prelims. And here, even the order can be passed ex parte. In section 144A, the period of 3 months has been mentioned. This period, 3 months, is important for your prelims. When we speak of section 145, this is a direct question for your prelims. In 145, Baja, it is the executive magistrate who has the power whenever there is a dispute regarding land or water and something which is likely to breach the peace. Moving on, now we come to the most important section, which is section 151. Section 151 is very important for your prelims. Again, in section 151, subsection 2, the time period has been mentioned, which says that no person arrested under section 151, which is an arrest to, to prevent the commission of a cognizable offense here. The time period again is not exceeding 24 hours from the time of arrest. You have to present the person arrested before a magistrate. Then we come to chapter 12. Chapter 12 itself is one of the most important chapter, and this chapter number is very important. That is chapter 12. Here we are talking about investigation. 2 to 3 questions are expected from this particular chapter. Section 154 is the most important chapter section here. It talks about information in cognizable offense. This particular section 154, it actually normally deals with the first information report also, but the first information report has not been mentioned. Now, whenever information is given to a police officer here of a cognizable offense has been defined under section 2C. But this information, it has to be noted down. It has to be signed by two people. By the person who's giving this information is going to sign this information, and it is going to be kept in the register which is maintained by the state government. Then if you come to the first proviso here, the first proviso says that if there is an offense which is committed under specific sections of IPC, that is section 326A, B, 354, A, B, C, D, 376, A, B, C, D, E, 509. In these particular cases, the information has to be recorded by a women police officer. This is also very important. Now, on this point, you have the landmark judgment of Lalita Kumari here. Under section 154, bacha, the copy of the information which is recorded, it has to be given to the person, that is the informant here. Informant can be anybody, even an accused can be an informant here. Then if the police officer refuses to register your first information report, now the remedy is you can approach the SP. Now the SP is going to lodge your FIR. This information has to be given in writing and by post. On this point, we come to section 155. 155, it is dealing with information when we speak of non-cognizable offenses. So 154 cognizable offenses, 155 talks about non-cognizable offenses. Now in section 155, subsection 1, it says if the information is given to the in charge of a police station here within the limits of your station, very important, you can underline this, that there is a non-cognizable offense that has been committed. Now there are two things that has to be seen here. This officer is going to record the information, and the word "and" is important here, underline. You have to refer the informant to the magistrate here. Now if you come to subsection 3 of section 155, it makes it very clear that if out of 3-4 offenses, even one of the offense is a cognizable offense, the entire chain will be considered as a cognizable case. So it is going to be a deemed cognizable offense. Now, if you come to section 156, 156 deals with the police officer's power to investigate a cognizable offense. This is a very important section. Here, a police officer, now he, without the warrant or the order of a magistrate, underline, he can investigate any matter which is, within which the court is having jurisdiction. Underline, this is a very important case again. Section 156 subsection 3 is very important for your prelims. It says that any magistrate who is empowered under section 190, he can order that the investigation can take place under section 156. Now, under this particular case, if there is a complaint, the complaint can also be treated as FIR. And in section 156 subsection 3, the most important point here is the magistrate is not taking cognizance of the offense. He is merely saying that the police can investigate the matter here. On this point, the landmark judgment is Sakira Vasu versus State of UP. Now you come to section 157. Section 157 is talking about the procedure that has to be followed for investigation. Now let's say if there is a information which is received, or there is any officer in charge of a police station, he has a reasonable there's a suspect that there's a particular person who has committed an offense. He can send a report to the magistrate. He can go make an investigation here. On this particular point, the proviso is very important, which says that if it relates to an offense where which is a specific offense, that is rape, now the recording of the statement of the victim here, it will be done at the residence of the victim here, or of any person of his particular choice. Here we have section 157, the second proviso, which is very important. And please remember that this was added by the 2009 amendment. So either the residence of the victim, or it can be any other choice of the victim's place. Then we come to section 160 and 161. Firstly, 160 is a very important section. It is talking about the police officer's power to require the attendance of the witnesses. Now, here, the police officer who's making an investigation, the word used is may. He can pass an order in writing, and he can require the attendance of any person who he thinks has information which is relating to a particular offense, or is acquainted with the facts of the particular case. But there is a proviso, and this particular proviso says that this was again added by the 2013 amendment. This was amended. It says that if there is a male person under the age of 15 years or above the age of 65 years, or there is a woman, or there is a mentally or physically disabled person, now again they are required to be examined where? At their residence or any other place where this particular person is actually safe. Now, on this point, we come to section 161, which is again a very important question for your prelims. This particular section was amended twice, one in 2009 and another in 2013. Now, examination of witnesses by police. In 160, the police officer is merely requiring the attendance. In 161, the police officer is examining the witness. And here, the police officer who's making the investigation here, who's in charge of the investigation, he can orally, the word is orally, he can orally examine any person who is acquainted with the facts and circumstances of a particular case. Now such person who is getting examined, they will be bound to answer the question. Now, if the police officer, he reduces the statement of the witness into writing, this statement is not going to be signed. Please remember this. This is a very, very, very important question, that the information, whatever statement has been given by the witness, this particular statement, it is not going to be signed by the witness. And section 161 subsection 3, it deals with case diary statement. It is also known as case diary statement. Now, the first proviso here says that you can use audio, visual, electronic means also. This was 2009 amendment. And then again, if there are specific sections of IPC, here it is going to be, the statement is going to be recorded by, and the examination of the witness is going to be done by a female police officer, not by a male police officer. On this point, section 161, the landmark judgment is Nandini Satpathy versus PH Dhani here. If you come to section 162, it is talking about the same thing. So this is an extension of section 161. It says that if there is any statement that you have given to the police officer by the witness, this statement is not going to be signed. Very important question here, that the statement, if it is reduced into writing, please remember this statement is not going to be signed, provided it is in the course of the investigation here. Okay. Though it is going to be a part of the record, but it is not to be signed. Very important. And the statement which is given under section 161, section 162 makes it clear that this particular statement can only be used for the purpose of contradiction, not for corroboration. It can only be used for contradiction. And section 145 of the Indian Evidence Act comes into picture here. Now, the subsection 2 of section 162 also makes it clear that section 162 is not going to affect two specific sections of the Indian Evidence Act, which is 32 and section 27. This is a very important question, section 32 and section 27. And section 162, there's a landmark case of Tehsildar versus State of Uttar Pradesh, where it was held that the doctrine of recital by necessary implication here. Always remember that the statement which is recorded under section 161, it cannot be signed, number one. Number two, it can only be used for contradiction, not for corroboration. It will not affect the provision of section 32 and 27 of the Indian Evidence Act. Section 164 is the most important section here. It is talking about the recording of confessions and statement. And the first important question here is, who can record this? It is going to be any metropolitan magistrate, any judicial magistrate. It does not matter whether they have jurisdiction or not. They are going to record the statement in the course of the investigation, and this has to be before the commencement of the inquiry or trial. So the inquiry or the trial has not commenced. It is only during the course of investigation that they can record this. Then here, if you are recording a confession here, please remember it can be done even in the presence of the advocate of the accused. This was added by 2009 amendment. Then no confession can be added by any magistrate on whom the power is not conferred by law under section 164. Then if you want to record a statement, Under section 164, the magistrate can record the statement also here. But when you record the statement has to be administered on oath. It has to be signed by two people. One, the person who is making the statement, and the magistrate. But when you speak of confession, please remember, confession is always signed by the accused as well as the magistrate, but it is never administered on oath. So this is very important here, that confession is never on oath, statement is always on oath. Then on this point, another important section here is section 164 subsection 6. Now under section 164 subsection 6, we are saying that if a magistrate has recorded a confession or he has recorded any statement, it has to be forwarded to that particular magistrate who is empowered to get the inquiry or get into the trial. So 164, these are the important questions for your prelims. When you come to section 164A, under 164A, you are doing the medical examination of the victim of the rape here. If there's a rape victim, you are doing their medical examination. This particular provision was added by the 2006 amendment. Here, please remember, the most important question here is that it always has to be with the consent of the women. It can never be without the consent of the women. This is the most important time. And it has to be within 24 hours of receiving the information that this particular woman has been subjected to rape. On this point, if you come to subsection 7 here, please underline, this is very important, that this section shall be construed as rendering, nothing in this section shall be construed as rendering lawful any examination which is done without the consent of the women. So if the examination of a rape victim is done without her consent, it is not going to be taken into consideration, that it has to be with the consent. Then you come to section 165. 165, it deals with the search which is done by a police officer here. Now, who can do the search is important. It is the officer in charge of a police station. He can make a search. When can he make a search? When he's doing an investigation, only then he can make a search here. On this point, please come to section 167. Now, 167 is again a very important question section for your prelims. It talks about what are you going to do? What is the procedure to be followed if your investigation cannot be completed in 24 hours? Now, let's say a person is arrested, he is detained in custody. The 24 hours of the time period has not been completed, as in the investigation could not be done in 24 hours. Now, what is going to be the procedure here? Now, this particular person, he is going to be forwarded to the nearest judicial magistrate who is available. This is the most important point here, that you have to forward this accused to the nearest judicial magistrate available. Now, does it matter whether this person, the magistrate here, should have jurisdiction or not? No, it does not matter whether he has jurisdiction or not. Now he can authorize that this particular person, he can be given into custody, and the time period is very important, bacha. It is not exceeding 15 days in the whole. Very important question for your prelims. The total time period is not exceeding 15 days. So we're talking about the initial period of custody. It cannot exceed 15 days as a whole. Now, let's suppose there is the person here who is, in the custody of the police here. Let's say the time period of 15 days has been completed. Now, if you want to extend the detention, you can do it. There are two time periods which have been mentioned under section 167. This is 90 days and 60 days. 90 days is going to be the case where the investigation, it involves an offense which is punishable with death, life imprisonment, or any kind of an imprisonment where the time period is exceeding, it is not less than 10 years. And 60 days is going to be the opposite case. That is where it relates to any other offense. Now, let's suppose the time period of 90 days and 60 days is also over. What is going to be the procedure? Now, the accused he is eligible for a default bail. So 167 also elaborates the principle of default bail. Now, if you can get the default bail, when are you going to get the default bail? Only when you, for this, refer to explanation 1. Only when the accused is in custody and he should be ready and willing to furnish bail. So till the time the accused does not furnish the bail, he has to be in the custody. He cannot claim his particular default bail here. If you come to subsection 4 here, that is the proviso here. The proviso makes it very clear that if there's a woman who's involved, who's under the age of 18 years, she is going to be sent in detention, which is going to be a remand home, or it can be any recognized social institution. Under section 167, subsection 2A, if you are talking about an executive magistrate, he can authorize the detention, but the time period should not exceed 7 days here. So this is again very important, 7 days. Now, please come to subsection 6 here. When we come to subsection 6, let's say the further investigation order has been stopped by the magistrate here. Let's say now the session judge is going to be empowered, if he is satisfied that this particular case requires further investigation. Now the session judge can order the further investigation. On this point, all of you, please, let's move forward, and we come to section 172. 172 deals with the case diary. It's not dealing with the case diary statement, it deals with case diary here. And under section 172, subsection 1A is very important. It says all the statement of the witnesses which are recorded during the investigation, they are to be inserted in the case diary here. Okay. Now the case diary, it can be used for 2-3 purposes. The first purpose is to refresh the memory of the police officer, very important. It can be used for contradiction also under section 161, please remember, and it can be used for 145 of Indian Evidence Act. So the case diary under section 172, it is going to be used for refreshing the memory of the police officer and to contradict the statement. Section 173, it deals with the final report here. Now in this point, if there is there's a child who has been raped, you have to the investigation relating to this particular child has to be completed within 2 months. Earlier the time period was 3 months, now the time period is 2 months. Section 173 subsection 8, it deals with the further investigation. So if the question is asked which section deals with further investigation, it is section 173 subsection 8 here. Section 174, it deals with inquest. Now, who can order the inquest here? You have DM, you have SDM, you have EM. Who can order inquest here? Subsection 2 talks about the situation when the inquest can be ordered here. If you come to section 176, this is very important. Now, if in case there is a death, now in the case of the death of whom? If there is a person who dies or he disappears, or rape has been alleged to be committed on any women, now the inquiry will be done by the magistrate here. This is a very important question. Who's going to do the inquiry? It has to be done by the judicial magistrate or a metropolitan magistrate. Remember, they should have the jurisdiction to actually do the inquiry in this particular case. Now we come to section 177. Now the chapter 13, it is dealing with the jurisdiction. Section 177 says that ordinarily the place of inquiry or trial is going to be that court where the offense has been committed. But section 178, 179, they deal with the other particular ramifications, and you have to give it you can just have a look on this. On this point, section 183 is very important because it deals with the extended jurisdiction. The concept of extended jurisdiction is given under section 183. Now, if you come to section 188, again, a very important question for your prelims. It deals with offenses outside, if any offense is committed outside India. This is known as extraterritorial jurisdiction. Very important question for your prelims. It is section 188. On this point, please remember that if you want to inquire into any offense which is committed outside India, it has to be only after obtaining the previous sanction of the central government. Otherwise, you cannot do it. So this is section 188. Now we come to chapter 14. Chapter 14 deals with the conditions which are requisite for initiation of proceedings. On this point, section 190 is very important. Section 190 is giving you 3 conditions that when can the magistrate, he can take cognizance of the case. 1, when he received any complaint. Number 2, if there is a police report, which is disclosing such facts. Number 3, you have received information from a person who's other than a police officer, or you have used your own knowledge. So out of your own knowledge, when you receive information, that is what section 190 is talking about. If you come to section 191, section 191 talks about the transfer on application of the accused. So here, if any magistrate has taken cognizance on, receiving information on his own, Now the accused here, the point here is before taking the evidence, very, very important point here is that the evidence has not been taken. The accused can file an application that he wants to be tried by some other magistrate. Now this application will be made to the CGM. But remember, it has to be before taking the evidence. Section 192, direct question, section based question is asked. Which section deals with making over of the cases by the magistrate? It's section 192. In section 193, we are talking about the court of sessions having the cognizance. Remember, the court of sessions, they can take cognizance of an offences as a case of original jurisdiction. So basically, only the court of session can take the cognizance of a criminal case as a court of original jurisdiction until and unless it is not committed to them by the magistrate here. Again, very important question here. So the magistrate here has to commit the case to the court of sessions. Only then he can take a cognizance of the particular matter. Section 195 talks about the prosecution for the contempt of lawful authority for the judicial or for the public servants here. So we have a category of offenses which have been given here. Please remember, in this particular section, a direct question is asked from the section that which section deals with the prosecution for the contempt of any lawful authority by a public servant. It is section 195. On this point, please come to subsection 4 of this particular section, and we come to B point, the B clause. This is again a prelims question. If appeal lies to a civil as well as the revenue court, civil and revenue court are also dealt with under section 195. You have subsection 4 clause B. Again, your prelims question, civil and revenue courts are there. Section 195A is a very important section. Again, it talks about the procedure for the witnesses in case of threatening. What procedure are you going to follow if the witness has been threatened? This has to be read with section 195A of the IPC, which talks about the offense of threatening a witness to give false evidence here. Again, very important here. If you come to section 197, section 197 deals with the prosecution of judges and public servants, that when can the judges or the public servants be prosecuted. So this is again a very important section for your prelims here. If you come to section 198 deals with the procedure when there is a prosecution of offences against marriage here. Okay. Section 198 subsection 2, this has been declared unconstitutional. Reason here is it deals with adultery. Since adultery has been declared unconstitutional in IPC, so similarly, this particular section has also been declared unconstitutional. On this point, if you come to the proviso of section 198, the second proviso, which is the B proviso here, if there is the person here who's complaining is a husband, and the husband is serving in the armed forces, now what is going to be the procedure? The procedure is he can he can allow somebody else also to file a complaint here. Now this complaint has to be in writing. This is an important point. This complaint has to be in writing, and the court is going to presume, which is a shall presume here, that the court is going to shall presume that this person had the authority to file a complaint here. Okay. So when you speak of section 198 subsection A, it is talking about the counterpart here is the cruelty which is committed under section 498A. Now, if you come to section 198B, it is speaking of how are you going to take the cognizance if there is an offense, which is section 376B, which is talking about this is a specific section where the husband has committed sexual intercourse with the wife without the consent during the period of your separation. It is not dealing with rape, it is dealing with without the consent here. So this is another important point. What is you remember that no court is going to take cognizance of this particular offense until and unless prima facie the police officer is satisfied that yes, it constitutes a particular offense. Section 199 deals with your prosecution for defamation here. In this particular section, subsection 2 is very important. Here, the session court, without committal in writing by the public prosecutor, he can only take the cognizance, otherwise he cannot take the cognizance in the case of defamation. So what is important here, please underline, this is court of session. He has to take the cognizance of the matter without the case being committal to it, and the complaint has to be made by the PP in writing, and the maximum time period which is given under section 199, bacha, this is 6 months. Remember, this is maximum period is 6 months. Now we come to the complaints which is made to a magistrate. We start with chapter 15 here. Now, under section 200, the magistrate is firstly going to examine the complaint. This is always on oath. So the complainant is also going to be on oath. The witnesses are also going to be on oath. So remember, complaint is always on oath. The proviso is very important here. It is basically dealing with the situation where the magistrate need not examine the complainant or the witness. This is very important question. When, number one, if there is a public servant, he is, he doesn't act during when he's discharging his official duties, number one. Number two, there is a magistrate who makes over the case, or it has been tried under section 192. So if there is a making over by the case by a magistrate under section 192, or there is a public servant here who is basically discharging his duty and then he commits an offense. So here examination of these two people under this situation is not required. You come to section 201. In 201, we are talking about the procedure that the magistrate, if he's not competent to take the cognizance, is going to be followed. If the magistrate is not competent, always remember, if the complaint is in writing, he's going to make an endorsement and he will send it back. If the complainant, if the complaint is not in writing, now the magistrate here is going to say that you please approach the proper court here. In 202, section 202, this question has been asked in your MP prelims also. If you speak of 202, the may and shall is going to take, it takes place here, and this is very important. If any magistrate here, when he receives cognizance of an offense, where he knows that he's entitled to take cognizance of, please remember, he may. And if he thinks fit, and he thinks that, the accused is going to be at a place where he exercises his jurisdiction, then it's going to be shall. If he exercises the jurisdiction, shall. Otherwise, the point is may. What can he do? He can postpone the issue of process. So the postponement of the issue of process is going to take place. And then what is going to happen? He can either direct an investigation that can be made, that can take place, or he can say that no, an inquiry should take place. Please remember, the word is may if it is outside his jurisdiction. The word is shall if it is within his jurisdiction and the accused is residing here. He can postpone the issue of process. And the proviso is very important. It deals with the mandatory provision. Both the proviso here, clause A, clause B, very important here. Okay, now if you come to section 203, 203 talks about the dismissal of the complaint. If the magistrate wants to dismiss the complaint, please remember the reasons have to be recorded in writing in every case. And if the complaint is dismissed, it is going to be the High Court or the Court of Session who can do the further inquiry under section 398. So 203 read with section 398. Now we come to the commencement of the proceedings before the magistrate, chapter 16 here. In this particular case, if the section 204 is dealing with the issue of process. In 203, what happened? It was 202 was talking about the postponement of issue of process. 204 is talking about the issue of process here. What is going to happen if it is a summon case? Now he's going to issue the summons. If it is a warrant case, now the magistrate here, he has an option. Either he can send summons, he can issue warrants also. On this point, please remember section 204. Subsection 4 is very important here. It says that if the court fees is not paid, then he can dismiss the complaint also. 205 deals with the when the magistrate can dispense with the personal attendance of an accused. 206 deals with the petty offenses. In petty offenses, remember the amount which is given, which is mentioned in the summons, it should not exceed 1,000 rupees. 205 deals with dispensing the personal attendance of the accused here, and 206 deals with your petty offenses. Now 207 talks about the fact that whenever there is there's a police case which is registered on a police report. Now the accused has to be supplied with all the necessary documents. The necessary documents are supplied always without any delay. It is given free of cost, and these includes the police report, the copy of the FIR here, then any statement recorded under section 161 subsection 3, any confession statement recorded under section 164, and bacha, if there is any other document that is which is recorded and which is relevant to the case under section 173 subsection 5. Now in 208, what is going to happen? You are going to supply the copy of the statements and the documents to the accused in cases which are triable by court of sessions here. This is a very important point here. Now, let's say there is a case which is instituted otherwise than on a police report. 207 deals with police report, 208 is dealing with otherwise than on a police report. Now, if this particular case is exclusively triable by a court of session, that is, let's say there's a murder case. Now, what is going to happen? What all documents are you going to give? You are going to give the statement which is recorded under section 200, 202, any confession, any statement recorded, any statement recorded in section 161, everything has to be given to the accused here. If you talk about section 209, this is very important. 209 deals with the committal of a case to the court of session when it is triable exclusively by it. Let's say there is a case which is instituted on a police report now or otherwise. So 208, it was dealing basically otherwise than on a police report. 209 deals with the police report. Now what is going to happen? If the accused is brought before the magistrate and the magistrate realizes that this is a particular case which is exclusively triable by the court of session, what are you going to do? Now the word used is shall. Now the magistrate is going to do one thing. He's going to comply with the provisions of section 207 that all the documents should be given to the accused. Then if there is this particular section, if there's any provision of bail, he's going to tell him that there are bail provisions which are applicable to him. If he wants to send the accused on remand, he can do that also. Then he's going to notify the PP. This is an important point. In 209, it is a committal of a case to court of sessions when the offense is triable exclusively by the court of session. Please remember, you have to notify the PP. The magistrate should notify the PP that the committal of the case has taken place here. Now 210, it talks about the consolidation of the cases. When I say consolidation of the cases, it means that when otherwise what happens, let's say when the case was instituted, it was instituted otherwise than on a police report, which is a complaint case. Later on, when the inquiry was taking place, it makes to the magistrate here that this particular case it should require the investigation of the police also. So what is happening? The magistrate, when he starts with the complaint case, he realizes that the investigation is already done by the police also. So simultaneously, two things are happening. Now what is going to happen? The magistrate shall word has been used. The magistrate is going to stay the proceedings of his inquiry or trial, and he's going to ask for a report from the police officer who's conducting the investigation. In 2010, please remember that simultaneously two things are happening. The inquiry is also taking place, the investigation is also taking place. Now the magistrate, he's going to stop, he's going to stay the inquiry or the trial, and he's going to call for a report from the police officer who's conducting the investigation. In subsection 2, it is very important now, if there's a complaint case also, there is investigation also going on which is out of a police report, how are you going to try the case? Now it is going to be consolidated and it will be tried as if it is a case which is instituted on a police report. Please remember this. Now it will be treated as a case which has been instituted on a police report. Now we come to chapter 17, bacha. Chapter 17 deals with charge. Now charge has been defined under section 2b. The section 211, it deals with the contents of the charge. Okay, that the content says that the offense should be stated. Then if the offense has a name, state the name. If it does not have a name, give the definition, give the law, give the section. It should be in the language of the court, and it should also state the time and the place when the offense has taken place. Okay, on this point, the most important section here is section 215. 215 deals with the effect of the error. If there is an error, what is going to happen now? Let's say there is an error which takes place, and if the accused is misled, plus there is a failure of the justice now, then the charges can be altered here. Okay. 216 is specifically dealing, this is the most important question for your prelims. When can the court alter the charges? Please remember, the court can either alter the charge or add the new charges any time before the judgment is pronounced. So till the time the judgment is not pronounced, the court has authority. They can either alter the charge, add the charge. It does not matter. Okay. Very important question. 216, very important question for your prelims. If you speak of section 213 also, there are certain illustrations which have been given, especially illustration B and C. Both the illustrations have been asked in your prelims. They require a quick reading. And if you come to section 221, now section 221, it deals with when you are in doubt which offense has been committed. At times, okay, so we come to section 221. Now, at times, what happens in section 221, whenever there is a act or there are series of acts, and there is a doubt which offense has been committed, then what is the court going to do? The accused here, he will be charged with all the offenses, and all the offenses are going to take place here. Okay, so the number of charges, they can be altered later on, but once the accused will be charged with all the number, and he will be tried with all the charges at once. Okay, on this point, everybody please come to section 223. Now, when we speak of section 223, bacha, 223 talks about what person can be, they can be charged jointly. So when can a joint trial take place? This is section 223. Direct question for your prelims. When can the joint trial take place? It is section 223 here. Section 224 is the most important section here, and section 224, bacha, it talks about the withdrawal of charges. Now, let's say whenever there is a charge which is there, okay, and it is issued on complaint. So this is a complaint case, and the charges has been framed here. Now, what happened? One second, all of you. So there is a complaint case here. Okay, so let's say there is a complaint case, and in complaint case, what happens? Let's say the conviction takes place. Okay, and the officer who's conducting the prosecution, he can withdraw the charges. Okay, the withdrawal of the charges here, all of you, you can have a look at the screen. We are on section 224. So we are on section 224, everybody. Yes. So this is very important, bacha. So whenever there is the conviction takes place in one particular, on the basis of one charge, now the officer conducting the prosecution with the consent of the court. This is very important. Here, the complainant is there with the consent of the court. What are you going to do? You can, withdraw the charges. Okay, the withdrawal of the charges can take place here, and please remember, this can either be, there are two options available with the court. Either the court is going to stay the inquiry, or the court is going to say that we can go ahead with the trial as it is. But what is going to be the effect here? The effect is going to be acquittal. Very important question under section 224. Please remember, whenever the charges are withdrawn, the effect is acquittal here. Acquittal of the charge takes place. Very, very, very important. Now we start with the trial. Okay. Now when we come to the trial, the first trial that we have is a trial before a court of session. 225 tells you that who's going to do the trial. The trial is going to be conducted by the PP here, that is the public prosecutor. Then the first time the discharge takes place under section 227. Now when the court, he considers that, after looking at the documents, that there is absolutely no sufficient ground to proceed against the accused, the first time the discharge is going to take place under section 227. Remember, there is no sufficient ground here, the discharge takes place. But now in 228, very important question for your prelims. In 228, what happens when the judge, he analyzes on that, yes, there is a presumption that the accused has committed any offense, but there are two things. This particular case is not triable exclusively by the court of session. If it is not exclusively triable by a court of session, the word used is may. Now the court may frame a charge and he's going to transfer the case to the CGM. Case to the CGM. Now the CGM is going to see which judicial magistrate is going to deal with the case. But the procedure here that is going to be followed, bacha, is going to be the trial of warrant cases instituted on a police report. Please remember, whenever we speak of section 228, the trial here is going to be trial of warrant cases instituted on a police report. But if it is exclusively triable by the court, now the word is shall. Now it is mandatory to frame a charge. Whenever the charges are framed, these charges are to be read and explained to the accused, and the court is going to ask the accused here, the judge is going to ask, do you plead guilty? Yes or no. In 229, let's say the accused pleads guilty, the judge is going to record the plea. Let's say in 230, the accused says, I do not plead guilty and I want to be tried. Now the judge is going to do what? He's going to fix a date. This particular date will be to examine the accused, and then issue of the process is going to take place, where you can compel the attendance of any witness, bacha, or it can be production of any document, or it can be production of anything also. In 231, now what is going to happen? The prosecution's evidence is going to take place. 232 is very important. Now the acquittal is going to happen in section 232. Why? If after taking the evidence of the prosecution, the judge has examined the accused, he has heard the prosecution, he has heard the defense, and the judge considers there is no evidence which is showing that the accused has committed the offense, now the judge is going to pass an order of acquittal. Why an acquittal is taking place here, bacha? Because the charges have been framed. In 227, it was discharged. In 232, it is acquittal. In 233, what happens if the accused is not acquitted under section 232? Now he's going to enter into his defense. Okay. Now when the accused enters into his defense, he can give a written statement also. He can give his answer in a written statement also. In 234, what happens? This is known as the stage of argument. Now, when the defense has completed, okay, when the examination of the defense is completed, the prosecution is going to sum up his case. Now, the accused or his pleader, they are also entitled to any reply. The important point here is the proviso, which says if any point of law is raised. Now, this is very important. If any point of law is raised either by the accused or by his pleader, now the prosecution may, with the permission of the judge, they can make a submission to this particular point of law. In 235, bacha, what is happening? In 235, the judge is going to pronounce his judgment. Okay. Now, when the judgment is pronounced, the important point is section 235, subsection 2, where if the accused is convicted, please remember, this is a mandatory provision here, that the judge is always going to hear the accused on the question of sentence here. Very important. The accused has to be heard on the question of sentence, a mandatory provision. 236 talks about previous conviction. If it is proved that he is, previously he was charged under any section of section 211, subsection 7, and the accused does not admit that, he has previously convicted any particular offense here. Now the word used is may. The judge may, after he has convicted, he can take evidence. It is not necessary. The word used is may. Section 236 deals with your previous conviction. You can skip this section, but you come to section 237, which is very, very, very important. In 237, we are dealing with the procedure which is to be followed in the case of section 199, subsection 2, which deals with defamation here. Please remember, who has the authority to take the cognizance? It is the court of session. The most important point here is the trial. How is the trial going to take place? It is going to be warrant cases instituted otherwise than on a police report. This is the most important question that can be asked. Please remember, in the cases of defamation, the court of session is going to take the cognizance. Warrant cases instituted otherwise than on a police report before a court of magistrate. Then every trial, it has to be in camera. Again, Please remember, this is in camera now. Now we come to the warrant cases. How are you going to try a warrant cases? By the magistrate here. We come to chapter 19, everybody. So when the warrant cases is started, the first part here is when the cases are instituted on a police report. First point is you have to see whether there is a compliance of section 207. If it is there in 239, if on considering the police report and all the documents that are there, if the magistrate thinks after after giving the prosecution and the accused an opportunity of being heard, these are the principles of natural justice. So after you've given the opportunity of being heard to the prosecution and to the accused, if the magistrate thinks this is groundless, now he's going to discharge. And the word is shall here. Okay, he's going to discharge. And remember, reasons are to be recorded. Why are you discharging here? Section 227 deals with discharge, then section 239 deals with discharge. We come to section 240. Now what happens? After considering after considering everything, and the magistrate assumes now there is a presumption that yes, the accused, maybe he has committed any offense. Now the charges shall be framed. In 240, the framing of the charges shall be done, and then the magistrate is going to read and explain the charges to the accused here. Okay. In 241, if he pleads guilty, he will be convicted here. In 242, let's say he says, no, I am not guilty, and he wants to be tried. Now what is going to happen? Again, bacha, the same procedure is going to follow, that you are going to fix a date for the examination of the witnesses, and everything is going to move on. The procedure in section 242, which is important, is the proviso. You have to ensure, the word is shall, the magistrate has to ensure here that the accused has been supplied with the copy that of all the documents or all the statement of the witnesses that were recorded during investigation by the police here. Then bacha, section 243, it is dealing with the evidence for the defense. When we speak of section 243, now the accused, of course, is going to enter into his defense. Okay. Now, when he enters into his defense, remember one thing here. In subsection 2, if the accused, once he enters into the defense, he can ask for examination. He can ask for cross-examination also, and he's going to ensure that there's a proper production of document or thing. Everything has to be done. And remember, his application can be refused also, and the grounds are if there is a purpose of delay. So if there is a purpose of delay, or there is a vexation and defeating the purpose, defeating the ends of the justice, now his statement, his request can be denied also, it can be refused also. But again, the reasons are always to be recorded in writing here. We come to section 244. Baja, in 244, the evidence for the prosecution is going to take place. Now, this is the B part. It is talking about those warrant cases instituted otherwise than on a police report. Okay. So here what is going to happen? The magistrate is going to hear he's going to hear the prosecution. He's going to hear all the evidence that is brought before by the prosecution here. In 245, again, the word discharge has been used. In 245, what happens? When the magistrate, he looks into the evidence given under section 244, and he believes there is no reason absolutely to proceed against the accused. Now what is going to happen? The magistrate shall discharge him. Now, the discharge word is shall discharge him. But again, reasons are to be recorded in writing. Very, very, very important. Please remember, reasons are always recorded in writing. So discharge takes place under section 227, 239, 245 till now. Now we come to, directly we move on to section 249 here. 249 is very important. Here we are talking about absence of the complainant. Very important question for your prelims. What happens? Let's say the proceedings are instituted on a complaint, and on the date which is fixed, let's say the complainant is absent. Now the complainant does not turn up. This offense is lawfully compoundable, or this is not a cognizable offense. Everybody look at the whiteboard here. Look at the screen. The offense, it may be lawfully compoundable, or it is not a cognizable offense. Now the magistrate in his discretion, if the charges are not framed, what are you going to do? You are going to discharge the accused here. Okay, the offense should be lawfully compoundable, not a cognizable offense. The magistrate in his discretion, in his discretion, charges are not framed, bacha, so the discharge takes place. Okay, now when we come to section 250, the important question here is the compensation for the accused without a reasonable cause. Please come to subsection 3 here. Subsection 3, bacha, it says that in case the magistrate, he can order directing the payment of the compensation in case of the default of the payment. And please remember, if there is, you were asked to make the compensation and you do not make the compensation, so there is a default in payment, you have to undergo simple imprisonment not exceeding 30 days. So it is simple imprisonment not exceeding 30 days. Again, this is your prelims question. Please remember, simple imprisonment not exceeding 30 days. Now we come to summon cases by magistrates here. Section 251, bacha, direct, it starts with section 251. It says that the substance of the acquisition has to be read. Okay, now in this particular section, the most important line is the last line, which is, it is not necessary to frame a formal charge. Most important line. So whenever you're talking about a summon case, it is not necessary to frame a formal charge. What is enough? Only substance of acquisition is enough. In 252, the conviction is going to take place. In 253, this is a section based question, and it talks about the conviction in the case of petty cases. Okay, now this is a direct question. Section based question is asked from section 253, that which particular section deals with the petty cases and the conviction can take place. It is section 253. Now on this point, all of you, please come to section 256. Come to section 256. Now 256, 257, 258, 259, direct question for your prelims. In 256, what happens? Non-appearance or the death of the complainant. Now the summons were issued on a complaint. On the date which was decided, bacha, let's say what happens? The complainant does not appear. When the complainant does not appear, now what is going to happen? Acquittal is going to take place. This is very important. Acquittal is going to take place until and unless the magistrate feels that yes, we need to have, we can adjourn the hearing. So in the case of non-appearance or death of the complaint, remember here, acquittal is going to take place. It is not discharge, it is acquittal. Okay. In section 257, you are withdrawing the complaint. Now what happens? You have to understand the pointer here. The first point here is, if the complaint at any time, first point, at any time before the final order is passed, underline at any point, before a final order, second point, then now what happens? The magistrate is satisfied that there are sufficient grounds, underline sufficient grounds, to do what? To withdraw the complaint. He can withdraw the complaint now. If he withdraws the complaint, bacha, remember again what is going to happen? Acquittal is going to take place. So in case of non-appearance or death of complainant, or in the case of withdrawal of complaint, what is going to happen? Acquittal is taking place. It is not discharge, it is acquittal that is taking place. Now the order of section 256, 257, 258, 259 is also very important. Okay, so remember the order, remember the section. 258, bacha, talks about power to stop the proceedings in summon cases. Now we are talking about a summon case which is instituted otherwise than on a complaint. Who has the authority? It is JMIC, magistrate first class, but he requires something. He requires the previous sanction of the CGM here. Okay, for reasons to be recorded, he can stop the proceedings at any time. This proceeding can be stopped when, without pronouncing the judgment, he can stop the proceedings. But remember, if the stopping of the proceeding takes place after the evidence of the principal witness has taken place, now it is going to be acquittal. But if it is before the evidence of the principal witness, it is going to be discharged. This is the important point here that you need to understand. If The stopping of proceeding takes place once the evidence of the principal witness has taken place, acquittal. If the evidence of the principal witness has not taken place, it is going to be discharge. Okay. Now you come to section 259. 259 bacha talks about the power of the court to convert the summon cases into warrant cases. So that means whenever the trial is going on, okay, and the trial is for a summon case which is relating to an offense which is punishable with an imprisonment, or which is a term exceeding 6 months. Now the term of imprisonment is doing what? It is exceeding 6 months. Now the magistrate thinks, in whose interest? In the interest of justice, that what to do, that we need to try this particular offense with the procedure of the warrant cases. Now the magistrate may, now he has two options. Either he can rehear the case in the manner which is provided in this particular code for the trial of the warrant cases, or he can recall any witness who has been previously examined. So two options. Either magistrate is going to rehear the case here, that means right from the very beginning, or he can recall any witness. Section 256, 57, 58, 59, very important. Now we come to summary trials. Bacha, summary trial section 260, chapter 21. Who has the power? This is a very important question. Who has the power? CGM has the power, MM has a power, then the CGM, that is the magistrate first class, also has a power. But the question here arises, can the magistrate of first class do it directly? No, he has to be empowered by the High Court. It is only when he is empowered by the High Court that he can try a particular offense summarily. Now come to section 261. When you come to section 261, it talks about summary trial by a magistrate of the second class. Now the question here arises, can the second class magistrate, get into a summary trial? Yes, he can do it, only when he is empowered by the High Court. And the second point is, offense should be punishable only with fine or an imprisonment not exceeding 6 months, or with fine. Abatement is also included, and attempt is also included. Very important question, bacha. The imprisonment should not exceed 6 months with or without fine, and only High Court has the power to confer any power on judicial magistrate second class. What is going to be the procedure that is followed in the summary trial? Bacha, it is going to be the summon case procedure that is followed, and the punishment here is maximum not exceeding 3 months. So the maximum punishment here is going to be 3 months. So in summary trials, please remember 262 talks about two things. Procedure of the trial will be summon cases, and the punishment is going to be 3 months. Now we come to section 265A. All of you, 265A. Now, but this is a chapter 21A. It deals with plea bargaining. Originally not a part of the CRPC. It was added by the 2006 amendment. The date is very important. It is 5th July 2006. Very, very, very important. In this particular chapter, we start with section 265A. When is this chapter going to apply? But this chapter is going to apply whenever the offender here, he has not committed an offense which is punishable with death, life imprisonment for a term not exceeding 7 years. Okay, so this is the first point that you have to remember here. It is not going to apply. Plea bargaining, bacha, never applies when the offense is committed against the women, when the offense affects the socio-economic conditions of the country, or there's a child below the age of 14 years against whom the offense is committed. Okay, so plea bargaining is not going to apply. And if you come to subsection 2, it says that the central government can notify that which particular offenses are going to affect the socio-economic conditions. All of you, if you look at your bare acts, we have 19 offenses which have been declared by the central government, which have been notified by the central government. All of you, in your comments section, it has been mentioned 19 acts have been given. Now you can write down 19 acts, that is the total number. So you have to read these 19, the name of the acts once. And remember, in India, we recognize sentence bargaining when we speak of plea bargaining. Okay. Now we come to section 265B. Who's going to file an application? But it is always going to be the accused who's going to file an application. In which court? In the court where the trial is pending. Okay. Now, along with the application, the accused is going to file an affidavit. In his affidavit, he's going to say that I am voluntarily preferring that plea bargaining should take place. Okay. And I'm understanding the nature and the extent, and I have not been previously convicted of any particular case here in which the charges have been the same. So once he does this, but this particular application is given to the court is going to issue a notice to the PP and the complainant as the case may be. Then what is going to happen? The PP or the complainant, they will be examined, and the examination is going to take place in camera. Okay. Now there are two things that can take place here. Now, if the court is satisfied, okay, that the application was filed voluntarily by the accused, we are on subsection 4, clause A. If the court is satisfied, Baja, that the application is filed voluntarily by the accused, now the court is going to give time to the PP or the complainant, and you can mutually, satisfy yourselves, and you can work it out a mutually satisfactory disposition, which is of course going to include the compensation also. But if the court finds that this particular application was filed involuntary, now what is going to happen? Either it is involuntary or the accused was previously convicted. Now the court is going to stop the proceedings and the case is going to start from the very particular stage where it was pending. Okay. Now what is going to happen in section 265D? All of you come to 265D. This is important for your exam, that which section deals with the report of the mutually satisfactory disposition. It is 265D. Direct question for your prelim, section based question is asked, 265D. Okay. In 265E, it is a disposal of the case. In the disposal of the case, we come to subsection 265, clause C. Now in clause C, but some punishment is given. If after hearing the parties, clause C, everybody, if the court finds that the minimum punishment for this particular offense, that has been provided, now what is going to happen? The accused is going to be given half of the minimum punishment. Okay. But in clause D, it is given if the court finds that the offense committed is not covered. That means the minimum punishment is not provided. Now it's going to be 1/4 of the punishment provided, or it can be extendable also. All of you, 1/4 of the punishment. In case it is minimum punishment provided, it's going to be half. Not provided, 1/4. Is the judgment of the court final? Yes, it is final. Please remember this judgment. Since it is a mutually satisfactory disposition, bacha, you cannot file an appeal against your plea bargaining. It is going to result only in SLP or in writ jurisdiction. Okay. Very important question here. Only SLP can lie under Article 136, or you can file a writ 226, 227. No appeal. Why no appeal? Because this is a mutually satisfactory disposition here. Okay. On this point, please come to 265K. 265K, bacha, talks about statement of the accused not to be used. Please remember, whenever any statement is given by the accused for the purpose of plea bargaining, it cannot be used for any other purpose. This is a very important question here. Can the statement be used for any other purpose? The answer is no. The word used is shall not. So, shall not be used for any other purpose here. Okay. Now we directly come to section 272. Everybody, 272. 272, please remember, it talks about the language of the courts. Who's going to determine the court? The state government is going to determine the language of the court. 273, bacha, it deals with the fact that can evidence be taken in the presence of the accused? Actually, it is incorporating the principle of constructive presence. It says that normally the evidence has to take place in the presence of the accused, but there are certain cases where the presence of the accused can be dispensed with, provided that. Now this is a question which is asked in your prelims. Which amendment talks about this? This is the 2013 amendment, bacha. Provided that where the evidence of a woman below the age of 18 years who is alleged to have been subjected to rape or any other sexual offense, now please remember, appropriate measures will be taken that this particular woman, she's never confronted by the accused. Okay. Of course, you have to ensure the right of the cross-examination of the accused, but The court will also ensure that this particular woman does not encounter the particular accused here. Then we directly come to one important section, all of you, which is section 280. 280 is your prelims question. It talks about the demeanor of a witness here. This question is section based question. In 280 we talk about the demeanor. So the demeanor of the witness is at times recorded by the judge here. Remember, section based question 280. Now all of you, in 281 what happens, the question that is asked in 281 is, which deals with recording of the examination of the accused here. The question that is asked is, this particular section is read with which section? It is read with section 164. Everybody, it is read with section 164. This is important. And one more thing is important. Does the provisions of section 281 apply to a summary trial? The answer is no. All of you come to subsection 6. Section 281, subsection 6, it says that this particular, the provisions is not going to, shall be, nothing in this section shall be deemed to apply in the case of a summary trial here. Okay. Interpreter is given in under section 282. Everybody, interpreter 282. Now, we come to the next point here, and that is, all of you, please directly come to section 294. 294 talks about no formal proof of certain documents. This is your prelims question. Section based question is asked. Which section says that you do not require formal proof of certain documents? But this is section 294. Okay. Now we come to section 300. All of you, please come to section 300. Now in 300, this is a very important provision. Section 300 says that a person once acquitted or convicted, he cannot be tried for the same offense. And the principle of the autiferous conviction or acquittal is dealt in this particular provision. This is a question which is asked normally in your paper. Okay, please remember. And both are included. The conviction is also included. The acquittal is also included. Now, on this point, please come to subsection 5. In subsection 5, it says a person who is discharged in section 258 shall not be tried again for the same offense except with the consent of the court. So you require the consent of the court if you have discharged a particular offense and a particular accused under section 258. In subsection 3, all of you, subsection 3, a person is convicted of an offense. Yes, it is convicted of an offense here. This particular section, section 300, it has to be read with article 20, everybody. It has to be read with article 20. And when you speak of article 20, we are not talking about direct article 20. We are talking about article 20, clause 2, which deals with double jeopardy. Article 20, clause 2, double jeopardy. But illustrations are very important in this particular section. But in section 300, the most important point in section 300, subsection 1 is when the acquittal or conviction remains in force. The word is when the acquittal in subsection 1, bacha, when the conviction or the acquittal remains in force. This is the point that you have to remember. When it is in force, you cannot be tried for the same offense on the same facts again. Illustrations, bacha, you have to give a reading to the illustrations. Section 303 deals with the right of a person against whom the proceedings are instituted to be defended as a matter of right. He can have, this is a matter of right of the accused here. He can be defended by a pleader of his own choice. Now, where do we find the provisions of legal aid in CRPC? It is section 304. 304 deal with the provisions of legal aid here. Please remember, it is legal aid, and the court that we are dealing is the court of session here. Okay, it is the court of session that we are dealing with. Now we come to section 306. 306 is a very important section here. It talks about tender of pardon to accomplice here. Now, in this particular section, if the stage is investigation, inquiry, or trial, bacha, it can be, the pardon can be tendered by either the CGM or it can be tendered by the MM, that is the Metropolitan Magistrate, at any stage. So these two, the CGM and the MM, they have the power to tender the pardon to accomplice at any stage, investigation, inquiry, or trial. But when you speak of JMIC, JMIC can only do it at the stage of inquiry or trial. He does not have the power to tender the tender pardon to accomplice at the stage of investigation. This is an important question, everybody. Very important question here. Sorry. Now we come to subsection 3 here. Section 306, subsection 3. The magistrate shall record, bacha, shall word has been used. He is going to record the reasons and whether this tender was accepted by the person or it was not. Okay, and this, the copy of this, the application here, it is going to be given free of cost now. Please come to subsection 4. Subsection 4 is a mandatory provision here. If you have tendered a pardon to an accomplice and he has accepted it, he shall be examined. The word is shall. Both the cases, the word is shall. He will be examined where? He will be examined as a witness in the court of magistrate. Okay, he will be examined in the court of magistrate, and he shall, until he is not on bail. So if he is not on bail, he will be in custody until the termination of the bail. Okay, the word again used is shall. This is very, very, very important mandatory provisions. If you come to subsection 5 here, bacha, in subsection 5, if the person, let's say he has accepted the tender of pardon and he's not examined, now the magistrate taking cognizance shall. Now again the word is used shall. He's not going to make any further inquiry. Without making any further inquiry, he is going to commit the case for trial. To whom? It will be committed to court of session if it is if it is exclusively triable by the court, or if it is triable by a magistrate who is taking cognizance here, but that magistrate has to be the CGM. Okay, and the other provision here is it can be a special judge also who is appointed under the criminal law amendment here. Okay, and if there's any other case, he can make over the case to the CGM. Now in section 307 here, bacha, in 307, what is happening? It is after the commitment. So when the tender of pardon is happening after the committal of the case, but before the judgment is pronounced. This is an important point here. When can you do it in 307? It is after committal, before judgment, that you have to understand. After committal, before judgment. In 308, what is happening? You have tendered, pardon to somebody. Now this person is not complying with the conditions. Now what is going to happen here? Number one, the PP here. The PP is going to certify. The power lies with the PP. He is going to certify what? That either this person is willfully concealing something which is essential, bacha, or he is giving false evidence. Okay, and he has not complied with the condition of the tender. Now what is going to happen? Such person is going to be tried for the particular offense. Okay, and he can also be charged for the offense of giving false evidence. This is also very important for your prelims. Can this person be charged for giving false evidence? Yes. This person can be made guilty and he can be charged for the offense of giving false evidence also. Now, can this person be charged jointly? No. This person shall not be tried jointly with any other accused, bacha. And please remember the proviso, the second proviso, it says you cannot try this particular person for giving false evidence except with the sanction of the High Court. So you require the sanction of the High Court if you want to try this person for giving false evidence here. Now, in subsection 2, bacha, any statement given by the person accepting the tender, it is going to be recorded as per section 164. Okay. Now on this point, please come to subsection 4, everybody. Subsection 4 says if the trial has started and the court shall, if it is a court of session, he's going to read out the charges, explain it to the accused. But if the court is a magistrate, before the evidence of the prosecution is taken, okay, they are going to ask the person here, have you complied with the conditions of the tender? If the accused, he says that yes, I have, if the accused does so plead that yes, I have complied, now the court is going to record the plea. The court is going to record the plea, bacha. And before passing the judgment, this is very important, and shall before passing the judgment, what is the court going to do? The court is going to find out whether the accused has complied with the conditions of pardon or not. Now, which order is going to be passed? Judgment of acquittal will be passed. Please remember, in 308, the last point, judgment of acquittal is passed. In 309, we are talking about when can you postpone or when can you adjourn the proceedings? Direct question. Please remember the first proviso, which talks about the time period of 2 months. This is very important, that whenever the trial relates to an offense under section 376, A, B, C, D, now it has to be completed. The trial has to be completed within a period of 2 months. 2 months from when? From the date of filing of the charge sheet. Okay, this is important here, bacha. Now, if you come to subsection 2 and you come to the proviso, the first proviso, it states, if you speak of the remand, the total time period is 15 days at a time. This is a question for your prelims. 15 days at a time here. Okay. Now, bacha, in this particular section, both the explanations, explanation 1 and explanation 2, they need to be given a reading here. Explanation 1, explanation 1 and explanation 2. Please give it a reading. Okay. Now, when can you give adjournment? The proviso makes it very clear that adjournment can never be given except the circumstances are beyond the control of the party. If, let's say, the pleader is busy in some other court, is this a ground for adjournment? No, this is not a ground for adjournment. Another important point is, bacha, if the witness is present, but the pleader is not present, now what is going to do? Now the court is, what is going to the court do? The court is going to record the statement of the witness, and they are going to consider and they're going to dispense with the examination of chief in chief or cross examination. So the statement of the witness will be recorded here. Okay, let's say the pleader is present, but he's not ready to examine or cross examine. So this particular clause C, is dealing with all the situation. Witness is present, pleader of the party, let's say they are not present, or if they are present, they are not ready to cross-examine. Okay, they're not ready to examine or cross-examine the witness. Now the court, in its own discretion, what are they going to do? They're going to record the statement of the witness, pass any order, and in this order, they can dispense with the examination in chief and cross-examination of the witness. In section 310, bacha, we are dealing with the local inspection. Who can deal with the local inspection? It can be any judge, it can be any magistrate also, it can be at any stage. So please understand, judge or magistrate in section 310, judge or magistrate, any stage, whether it is inquiry, trial or proceeding, but due notice has to be given to the parties. Now they can visit and they can inspect the place. In section 311, now the power, this is a very important question for your prelims again, section based question, bacha. Does the court have the power to summon material witness? Yes, the court may. The word used is may. It can be at any stage, but beta, inquiry, trial or proceeding, they can summon any person as a witness. They can examine any person in attendance. It is not necessary that this person should be called as a witness. Okay, so they can recall, they can re-examine. The court here can do everything. This has to be read with section 165 of the Indian Evidence Act. Okay, section 165 Indian Evidence Act. Now we come to section 311A. In 311A, bacha, the magistrate has the power to order to give specimen signatures or handwriting. Which magistrate are we talking about? We are talking about JMIC here. The purpose can be investigation, the purpose can be proceeding also. Both are included here. And here we are just talking about specimen signatures or handwriting. This provision was added by the 2005 amendment. The latest case law on this point is Ritesh Sinha versus State of Uttar Pradesh. Bacha 2019, in which the Supreme Court has held that the magistrate can order voice sampling also at the stage of investigation. It is Ritesh Sinha versus State of UP 2019. Voice sampling can also be ordered at the stage of your investigation here. Okay. Now we come to section 313. 313, very important question for your prelims. It deals with the power to examine the accused. Always remember, this particular provision is never on oath. 313 is never on oath. Okay. It can be any inquiry at any stage of trial. The accused, for the purpose of enabling the accused to personally answer at any stage, may word has been used. May at any stage, without giving previous warning to the accused, the court can ask him any questions. Okay. Now, if you come to clause B, it is shall. Shall, after the prosecution's witnesses has been examined, but before he has been called for defense, now he can be asked any questions. Okay. So remember, any stage without warning may. If the prosecution's witnesses have been examined, now the word is shall. Okay. In case the personal attendance has been dispensed with, that can be taken place. No oath shall be administered. 313 is never on oath. Please remember, statement under section 313 is never on oath. Okay. Subsection 3. Very important. Bacha, this is never on oath. I'm telling you, this is very important for your prelims. In section 313, when you come to subsection 3, all of you come to subsection 3. Let's say the accused refuses to give the answer. He shall not render himself to punishment. Either when he refuses, so no punishment can be given to him if he refuses to answer or he gives false answers. Then the next particular point is also very important, subsection 4, which says that if the answers which are given by the accused should they be taken into consideration? Yes, they may be taken into consideration. They may be taken into consideration. The word is not shall, it is may, the word which has been used. The fifth subsection is very important here. The court may. The court may. He can take the help of the prosecutor and the defense counsel, and he can ask them to prepare relevant questions, and these relevant questions can be put to the accused. And this also deals with the may permit filing of written statement. Remember, filing of written statement by the accused is going to be a sufficient compliance under section 313. This question has been asked in MP. This question has been asked in Delhi also. So this is a very important question. Subsection 5, put a star. This is very important. The word used is may. Now we come to section 314. Section 314, bacha, it deals with the oral arguments and the memorandum of arguments. Now again, the word used is may. Okay. Now the party to a proceeding may, as soon as the evidence has been closed, they can concise, they can address with the oral arguments here. The copy of these arguments, the memorandum, shall be simultaneously furnished to the opposite party. Subsection 2 deals with the copy of the memorandum. This copy shall be furnished. Can adjournment be given for filing of the written arguments? No adjournment will be given. Okay. Please remember, no adjournment will be given until and unless the court thinks they want to give adjournment. Please record the reasons in writing here. Now, come to section 315. Again, very important question. Direct question is asked from this particular section. Can accused be a competent witness? Yes, an accused can be a competent witness. The word used is shall. He shall be a competent witness. But again, can he be called without his consent? No. He can only be called as a witness on his own request in writing. Very important. On request in writing. And the statement given in section 315, bacha, this is on oath. So the evidence that the accused is going to give when he becomes a competent witness, it is on oath. Please write it down. Highlight, bacha. 315 is on oath. And let's say the accused, if he fails, if he does not give the evidence, are you going to raise any presumption against him? No. The answer is no. You cannot raise a presumption against him if he fails to give evidence. Okay. So failure to give evidence shall not be subject to any presumption against him. 315 is always on oath. The defense may give evidence on oath, bacha. Okay, 316, direct question, no influence can be used here. 317, again, it is your prelims question. A direct question is asked, which is a section based question. You don't have to give it a conceptual clarity. This is a section based question here that can be asked, which deals with the dispensing of the personal attendance here. Remember, the stage is inquiry or trial here. It can never be investigation. It's going to be inquiry or trial under section 318. 319, section 318 first. Let's say the procedure when the accused does not understand the proceedings. So, bacha, if the accused does not understand the proceeding, let's say he is not of unsound mind, but he still does not understand the proceedings. Now, what is going to happen? Now, the court is going to proceed with the inquiry or the trial. If the court is other than the high court, this proceeding can result, if the proceedings are resulting in conviction, the proceedings will be forwarded to whom? To which court? It will be forwarded to the high court with the report of the circumstances of the case. Now in section 319, what is going to happen? In section 319, if the stage of inquiry is happening, if the stage of the trial is going on, and it appears that the accused, this particular person who's been committed, who has been accused of convicted any particular offense, he is not the only one. Now the court can proceed against such person. Some other person has to be tried, the court can proceed against such other person also along with the accused. Okay, if that person, bacha, is not attending the court, then he can be arrested, he can be summoned also. If let's say he can be detained also. Okay, remember, if he's not arrested, he's not upon a summon, he can be detained also. If he's attending the court, not attending, he can be arrested or summoned. If he's attending, then he can be detained also. Now in this particular case, there are two remedies available with the court. The court is either going to start the proceedings afresh and they're going to rehear the witnesses, or what is going to happen, the court will proceed from that particular stage only, from where the stages of the trial is going on. Okay, section 320, very important. It deals with the, this is again a very important question for your prelims. It deals with the compounding of offenses. In compounding of offenses, bacha, let's just quickly discuss about the compounding of offenses. In compounding of offenses, come to subsection 3. In subsection 3, if the offense is compoundable, bacha, its abetment is also compoundable, its attempt is also compoundable. If the person, yes, abetment is compoundable, attempt is compoundable. If, bacha, if the person is here is under the age of 18, he's idiot, he's lunatic, now what is going to happen? He can compound it only with the permission of the court. If the person who was to compound the offense is dead, bacha, his legal representative can do it, but only with the consent of the court. Okay, now what is going to happen in this particular case? You come to subsection 6. The high court or the court of session, when, bacha, they are dealing with their power of revision, they can also allow compounding. High court or court of session are the only courts that have the power of revision here. When they're acting under the power of revision, they can also order for your compounding. And subsection 7, please remember, no compounding will take place if there is a previous conviction, or the accused is liable to enhance punishment, or there is a punishment of a different kind here. No compounding will take place. What is going to be the result of compounding? Very important question. It is going to have the effect of acquittal. It is going to have the effect of acquittal. Again, very important question. Now, bacha, can compounding take place under any other section? No, compounding can only take place if that particular offense is mentioned under section 320. If the offense is not mentioned under section 320, no compounding is going to take place. Now you come to section 321, withdrawal from the prosecution. Now, bacha, the PP or the assistant PP, only with the consent of the court. This is very important. Only with the consent of the court, any time before the judgment is pronounced, bacha, they can withdraw from the prosecution. If the charges are not framed, discharge. If the charges are framed, remember, acquittal. So in 321, three things are important. Number 1, when can you withdraw? With the consent of the court, any time before the judgment is pronounced. If charges framed, now what is going to happen? acquittal. Charges not framed, discharge. Now, all of you, please come to section 323. 323, bacha, this is again a section based question which is asked in the paper. If there is an inquiry or an offense of a trial going before a magistrate at any particular stage, he thinks that this particular offense should be tried by the court of session. Now he is going to commit the case to the court of session, and look at the stage. It can be any stage. In 323, it is any stage before signing the judgment. Before signing the judgment, to whom are you going to actually give it for the trial? It is going to be the court of session here. Okay. Now, all of you, please come to section 327. All of you come to section 327. Again, direct question for your prelims. Which section deals with the fact that the court has to be open? Section 327. Direct question, prelims question. All of you, section based question is asked. Courts to be open, section 327. Now, all of you, let's move on to the next provision. Let's move on to the next provision, all of you. Please come to section 334. In 334, section based question is asked in the paper that what is going to be the result of unsoundness of mind. Now, this is very important. Whenever any person, bacha, he is acquitted, and the ground is that at the time, of alleging this particular offense, unsoundness of mind is there, and he was incapable to understand the nature of the act. Please remember, what is going to take place? The judgment of acquittal is going to take place. Okay. Now the court is going to record the findings. The court is going to record the findings, and they have to state whether he has committed the act or not. So the statement has to be recorded here. The reasons are to be recorded here. Please come to section 340, all of you. Please come to section 340. But in 340, the procedure is given in the case of section 195. Okay. Now, in this particular case, what is important is the pointers that have been given to you. The court has to record a finding. They have to make a complaint. They have to send this particular copy to the JMIC, and then they have to take sufficient security also, and they have to bind the person to appear and reappear here. Okay. Now, please come to section 343. Again, very important. 343, everybody. In 343, magistrate, procedure of the magistrate taking cognizance. Bacha, now let's suppose there's a magistrate to whom the complaint is made under section 340 or 341. This is a question that you have to remember. The procedure will be as if it was instituted on a police report. The trial will be as if it was instituted on a police report. This is very, very, very important. As if it was instituted on a police report. In 344, there is a summary procedure which is given for the trial of giving false evidence. Two courts have been given the power, bacha, court of session or the JMIC. 344. All of you, 344, bacha. Two courts have been given power, court of session, JMIC. Now, the punishment has been provided here. The punishment is 3 months or 500 rupees of fine or both. Okay. 3 months or fine of rupees 500 or both. And what procedure are you going to follow? The procedure is going to be summary trial. The procedure is going to be summary trial here. Everybody. Procedure is going to be summary trial here. Okay. Come to section 347. Please come to section 347, everybody. In 347, can the registrar or a sub-registrar be considered as a civil court? Yes. Section 347 is making it very clear that the registrar or the sub-registrar will be deemed to be a civil court. And who's going to direct them? It is going to be the state government that directs. In 348, we are talking about the discharge of offender or submission on apology. Let's say there is a court under section 345. They adjudged an order of punishment. Okay. Or they have forwarded this particular matter to the magistrate for trial. Now the court in its own discretion, if the offender, he submits an apology, the court can discharge the offender also. So in 348, we are dealing with discharge of offender. in this particular question, what is normally in this particular section, it is a section based question that is normally asked in the prelims. Okay, so which section deals with discharge of offender on submission of apology? It is section 348. In 349, bacha, there is an imprisonment which is given if a person refuses to answer or he refuses to produce a document here. Now here the word is any person or any witness. What is going to be the punishment? The punishment is going to be not exceeding 7 days. All of you, 349, not exceeding 7 days is the punishment here. Please come to section, all of you come to section 350. Let's say there is a non-attendance by a witness and summons were issued to him. Now in this particular case, the fine is given. The fine is not exceeding rupees 100. All of you, section 350, fine not exceeding rupees 100, and the procedure that has to be followed is going to be of a summary trial. Sorry, in section 350, please remember fine of rupees 100 and the procedure is going to be summary trial. Please come to section 351. If there is an appeal, this particular appeal here, it is going to be go to the court which is ordinarily having the power to deal with the appeals. Okay, but when you come to section 351 subsection 3, all of you, 351 subsection 3. Now, bacha, in this particular case, please, this is a very important question. If there is a conviction by a court of small causes, please remember the appeal is going to lie to the court of session. Okay, appeal from the conviction by a court of small causes, the appeal is going to lie to the court of session. Again, an important question for your prelims. Now come to the next chapter. Let's come to judgment now. All of you, which section deals with judgment? Please remember the judgment is given under section 353, and the three ways here. Either you are going to deliver the whole judgment, you can read out the whole of the judgment, or you're going to read out the operative part. 354, bacha, deals with the language of the judgment. 354 deals with the language. The language, it has to be, it shall be written in the language of the court. Again, it shall contain the point of determination, or if there are more than one point, write down the point of determination. What was the decision taken on that particular point of determination? And you have to give the reason also. If there is a offense, specific offense of IPC, please mention that particular offense. And remember, in section 354, we are not just dealing with IPC, we are dealing with any other law also. So it can be any other law or IPC. You have to mention. If the order is of, the judgment is of, it is acquittal, state the offense. And then you're going to write down that this particular, accused, now he is at liberty. Please remember, if there is a doubt, which sections have been mentioned, then the court shall distinctively express the same. The court shall distinctively express the same, and the judgment will be passed in the alternative. Now, if let's say there is an offense which is punishable with death, or let's say, in alternative, what have you given? You have given imprisonment for life or any particular term. Now you're going to state the reason. The judge is going to state the reasons why you have given this particular sentence here. If the conviction is for an offense which is punishable for a term exceeding 1 year, but you have given, you impose a sentence of less than 3 months, again, you have to record down the reasons here. Now, if death sentence has been given, please remember the sentence shall direct. You to write down in the sentence that this particular person shall be hanged by the neck till he is dead. Okay, all of you, come to section 357 now. 357. But 357 deals with the order to pay compensation. This is very important. In section 357, subsection 1, it says, please underline, when the sentence of fine or a sentence of which fine forms a part. So section 357 subsection 1 says when fine forms a part. Okay, and subsection 3, section 357 subsection 3, bacha, it says when the court imposes a sentence when the fine does not form a part. So in this particular case, what happens? The prelims question that which section deals with the provision that the court imposes a sentence where fine does not form a part. Now, in this particular case, what is going to happen? The court, when they're passing the judgment, they're going to order the accused person to pay by way of compensation. Now he has to pay compensation of the amount which is specified in the particular order. Okay. Now this compensation will be given for the any loss of injury or anything or any reason by which the accused person was so sentenced. Okay. Now this order is a appealable order. You can go to the appellate court, or you can even, this can be passed by the high court or the court of session when they are awarding their, when they're exercising revision also. And please remember, if at the time of awarding the compensation in any subsequent civil suit relating to the same matter, what is going to happen? The court shall take into account if any particular sum was paid. 357A is a very important question which deals with the Victim Compensation Scheme 2009. Now the question that is asked is, who prepares this particular scheme? This scheme is particularly prepared by the state government in coordination with the central government. This is the most important point here. State government in coordination with the central government. It is not cooperation, bacha. At times they ask you in the prelims. Last time also it was asked whether it is cooperation or coordination. No, this is coordination. In coordination with the central government here. Okay. Now, if you come to subsection 3, if the trial court, now the let's say at the conclusion of the trial, if they're satisfied that the compensation given under section 357 is not adequate, now what is going to happen? The victim here, he has to be rehabilitated. So arrangement will be made that this particular victim, the court is going to make a recommendation for the compensation. Which court? The trial court here. Let's say the offender is not traced, that the offender is not identified only who has committed the offense, but the victim is identified. Of course, the trial has not taken place. To whom are you going to make an application? You are going to make an application to the state or to the district legal services for award of compensation. Okay. Now, if you come to subsection 5, bacha, now when the state or the district legal services, they receive this application for the recommendation, and the time period which is given is 2 months. In 2 months, you have to give the compensation here. This is very important, 2 months. Now, section 357B, bacha, this is a specific section. This was added by the 2013 amendment, and it is dealing with section 326A, and it is dealing with gang rape. So imagine, in this particular case, the compensation which is payable by the state government under section 357A of CRPC, but this is going to be in addition. Please underline, in addition to the payment of the fine which the victim has received under section 326A, that is asset attack, or section 376D. Please underline, in addition to the payment of fine. All of you, remember, this is in addition to the payment of fine. This is in addition to the payment of fine. Okay, now all of you, let's move on to the next section. It is section 357C. In 357C, we are talking about the treatment of the victim. Okay, now here in treatment of the victim, bacha, remember, it does not matter whether the hospital is public or private. Both are liable. Whether it is a central government or it is a state government, they immediately have to provide the first aid or the medical treatment free of cost to the victims who are covered under these particular sections, which are section 326, 376A, B, C, D, or 376E. And this information has to be immediately informed. You have to inform the police. If, let's say, this is not, you do not obey this, the hospital does not obey this, now you are liable under section 166B of IPC. So punishment can be given to you under section 166B. If you come to section 358, bacha, 166B, okay, of IPC. If you come to section 358, it is basically talking about the compensation that is given to a person who was groundlessly arrested. The fine here is not exceeding 1,000. Please underline, fine is not exceeding 1,000. And let's say the compensation is given, but it is not rewarded, as in it cannot be recovered now. You have to undergo a simple imprisonment not exceeding 30 days. Simple imprisonment not exceeding 30 days. Now, if you come to section 360, bacha, section 360, it talks about order to release a person on probation or of good conduct. Now, the parameters here are that if the person is, above the age of 21 years, fine, imprisonment of up to 7 years or less has been awarded. And if the person is under 21, okay, or the person here is, let's say she's a woman, and death or life imprisonment has not been awarded, now what is going to happen? You can release the person on your probation here. Okay, this entire section 360, it requires a quick reading. Normally the question is asked from section 360 subsection 1, but this particular section, it just requires a quick reading here. Okay, on this point, please come to section 361. In 361, bacha, if you are recording any you're recording reasons for, if let's say there's an accused person under section 360, you have sent this person on probation, or there's a youthful offender under the Children's Act. Here all the reasons have to be they have to be recorded in writing. So if there's a special reason, record down the special reason. Section 362 at the same time is telling you that the court is not to alter the judgment. So until and unless it is a clerical error, it is an arithmetical error. There are two errors which have been mentioned, bacha, clerical or arithmetical. If these are not the two errors here, the court does not have the power to alter the judgment which is being given. Now, all of you, please come to section 366. Come to section 366. Now, section 366 basically says that the death sentence has been passed by the court of session. Under section 366, bacha, the submission takes place. Now you have to submit to the High Court that you have sentenced this particular person to death. There are two sections which are asked from this particular chapter, which is 366 and 368. The submission to the High Court takes place under section 366, bacha, and the confirmation is given by the High Court under section 368. Remember this. 366 deals with the submission, 368 deals with the confirmation. So there are only two sections which are most important: submission 366, confirmation by the High Court 368. Don't get confused in the paper. This confirmation, bacha, it has to be signed by two judges. Okay, two judges, they have to sign. It can be two or more. Section 369, two or more judges. Okay, on this point, everybody, we come to the topic of appeal. Now, when we speak of appeal, section 372 is directly telling you that no appeal shall lie from any judgment or order of a criminal court. The word used is criminal court. So here, it cannot be claimed as a matter of right. Okay, it can never be claimed as a matter of right. It is only mentioned under section 372. So this is a statutory right, not a constitutional right. This is a statutory right, and it can only be claimed as per the provisions given in CRPC. And if you look at the proviso, when can the victim, appeal? The acronym here is ALC. ALC. Number one, everybody. If ALC, okay, provided that the victim shall have a right to appeal against an order if the court has acquitted the accused. Number one, the A stands for you have acquitted the accused. A stands for acquitting the accused here. But second point, lesser offense has been provided to him. So first, A, acquitting the accused, then lesser offense, you've been convicted for lesser offense, or what has happened? The compensation that has been given to you is less. Okay, so A, acquittal, L, lesser offense, then C, the compensation is less here in advocate. Now you can appeal. In section 373, we are talking about appeal from orders which are, specific orders under section 117, 121. Please remember, if the question is to whom will the appeal lie under section 117 or 121, it is the court of session, bacha. 117, 121, court of session. We come to appeal from conviction. Now, 374 directly deals with the court of conviction. Remember, any person convicted on a trial by a high court in its extraordinary original criminal jurisdiction, to whom are you going to appeal? You're going to appeal to the Supreme Court. If you have been convicted by session or additional session judge. Now, or let's say there is a sentence which is more than 7 years. Now, whom are you going to appeal to? You are going to appeal to the High Court. The question that is normally asked in the paper is subsection 3. If you are convicted by metropolitan magistrate or even assistant session judge or JMIC or magistrate second class, or you are sentenced under section 325 or under 360, please remember, court of session. This is the question for your prelims. The appeal against the judgment passed by the assistant session judge lies to court of session. It does not lie to the High Court. Assistant session judge, very, very, very important. Okay, 375. No appeal in the cases where the accused pleads guilty. This is a direct question. Section-based question is asked in the paper, bacha. If the accused, he pleads guilty, now there is going to be no appeal. If the conviction is by the High Court or if the conviction is by the court of session, metropolitan magistrate, judicial magistrate first class or second class, except on the legality of the sentence or on the extent of sentence. Okay, so 375, the question that normally asked is, if the accused pleads guilty, can you appeal? Can appeal lie? No, appeal will not lie. Come to section 376, it talks about no appeal in petty cases. Now, when we come to section 376, it says that no appeal is going to be there in the petty cases. Let's say the High Court has passed a sentence for a term not exceeding 6 months or a fine exceeding 1,000. Please remember, this is important. High Court passes only an imprisonment for a term not exceeding 6 months or for a fine not exceeding 1,000. Court of Session or Metropolitan Magistrate, it passes imprisonment not exceeding 3 months, bacha, or a fine not exceeding 200 rupees. Magistrate first class passes 100. This is important. This is normally asked in the paper, 100 rupees. And if the case is tried summarily, now it is going to be 200 rupees. Now it's going to be 200 rupees. Please come to section 377. In 377, we are talking about appeal by the state government against the sentence here. Okay. Now the state government here, if the conviction has taken place on a trial by any court other than a High Court, now they can direct the PP that you have to appeal, and the ground is very sufficient. The ground is against the sentence. Everybody, please underline this point. And appeal against the sentence on the ground of its inadvocacy, that you've given lesser sentence here. To whom? You are going to apply to the Court of Session if the sentence is passed by the magistrate, and to the High Court if it is passed by any other court here. Okay? High Court if any other court, to the Court of Session if it is given by the magistrate here. Okay? Come to section 378. 378, bacha, it deals with your... It talks about appeal in the case of acquittal. Now, in the case of acquittal, let's say acquittal has taken place now. Okay. Now, what is going to happen? The DM, very important. First point, the DM in this particular case, he is going to direct the PP that you file an appeal in the Court of Session. Okay. Why? Because the order of acquittal has been passed by a magistrate in respect of a cognizable and a non-bailable offense. And in the case of the state government here, now the state government is going to direct the PP. You file an appeal in the High Court here because the order of acquittal was passed by the Court of Session in revision. Okay? Please understand this. So the DM will do it. The DM is going to direct the PP, file an appeal in the Court of Session if the order of acquittal is passed by the magistrate. In case of, if the order is passed by the session here, session court here, the state government is going to direct. Now on this point, please come to subsection 5 here. In subsection 5, it says, no application under subsection 4 for the grant of SLP. SLP cannot lie, bacha, when? Please write down. If the complainant is a public servant, underline. After the expiry of 6 months, number 1. Number 2, where the complainant is a public servant, and after 60 days in any other case. So this is very important, and you have to compute this from the date of acquittal here. Okay. So the SLP will not be entertained by the High Court after the period of expiry of 6 months if the complainant is a public servant, and 60 days, and sorry, 6 months where the complainant is a public servant, and 60 days in any other case. I'm so sorry. 6 months in the case of the public servant and 60 days in any other case. Okay. Now please come to subsection 6 on this point. If in any case the application under subsection 4 for the grant of your SLP from the order of acquittal, bacha, it is refused, can you order an appeal from that particular order of acquittal? The answer is no. No appeal from the order of acquittal here. Am I audible? Okay, so moving on this point, bacha, we come to section 380. Now, bacha, section 380 talks about special right of appeal. Now, this is a direct question that is asked. This is a section-based question which is asked. Which section deals with the special right of appeal? It is section 380. Bacha, section 381, it talks about how the appeal to the court of session has to be heard. Okay. 382, this is important for your prelims. The petition of appeal is dealt with. So they ask you whether it is memorandum or it is something else. The word used in CRPC is the petition of appeal. It is not memorandum of appeal. Okay. So 382 deals with the petition of appeal here. 383 bacha deals with the procedure when the appellant is in jail. So when the person who's applying for the appeal, he's in jail. Now what is going to happen? The procedure will be given under section 383. You have to follow this procedure. Direct question for your prelims, section based question is asked from section 384. It talks about summary dismissal of appeal. 384 bacha, summary dismissal of appeal. Direct question, section based question is asked from this particular section. If you come to section 386, all of you, section 386 deals with the powers of the appellate court. Very important provision here, section 386. Now in section 386, what is happening, bacha? When the appellate court here, when the appellate court, he's going to okay, so in section 386, we have to deal with the powers of the appellate court here, and you have to understand, just go through section A, B, C, the subclauses A, B, C. That's it. You don't have to go it in detail. Just read section 386 once only. Okay, all of you, please come to section 394. Section 394. Now, section 394 deals with the abatement of your appeals. This is a direct question for your prelims, section-based question. 394, abatement. In 395, bacha, we are talking about the reference. Now, in section 395, the reference can be made to the High Court. Always remember, wherever the court is satisfied that there is a substantial question of any validity of law or ordinance is required, now the matter is going to go to the High Court. So reference will be given to the High Court here. In 397, bacha, please come to section 397. The calling for the records to exercise powers of the revision. In this particular section, section 397, two courts have been mentioned. The High Court and the Session Judge, they have been mentioned. So they have the power of revision. In 398, what is happening? Power to order, inquiry has been given. But most important question here is section 399 and section 401. Section-based questions are asked, bacha. In 399, we understand the Session Judge's power of revision, and in 401 we are dealing with the High Court's power of revision. Okay, 399 Session Judge, 401 High Court's power. Then we come to section 402 everybody. In 402, the High Court has the power to withdraw or transfer the revision cases. Okay, so if the question is who has the power to transfer or withdraw the revision cases, it is always the High Court. Please understand, 402, underline 402, it is the power of the High Court here. Okay, now we come to the transfer of criminal cases. Please come to section 406, everybody.
In section 406, bacha, subsection 2, the Supreme Court can transfer the application here in subsection 2 only. The word only has been used on the application of the Attorney General of India or any party interested. So in 406, we have the Supreme Court dealing with the application of the Attorney General or any other party interested. Okay, so you have to give an affidavit. And if the state is involved, then it has to be AG here. Okay, in 407, bacha, we have the power of the High Court to basically transfer the cases or the appeals here. You can give it a quick reading, all of you. Bacha, you come to section 416. 416 is very important. In 416, what happens? We are talking about the postponement of the capital punishment on pregnant women. So if the sentence of death is given to a woman and later on she is found to be pregnant, High Court has the power. 416. High Court can compute the sentence to imprisonment for life. So it is the High Court who can commute the sentence here. 416, bacha, very important. Section 420 is your section based question that is normally asked in the paper. That if the prisoner, he is to be confined in the jail, to whom will the warrant be issued? The warrant will be lodged with the jailer. In 420, the warrant is lodged with the jailer. Bacha, now please come to, all of you, please come to section 427. In section 427, the subsection 1, please read it carefully. The normal provision here is that each sentence here, bacha, it is going to run consecutively unless the court says that the subsequent sentence shall run concurrently. Normal rule is consecutively unless the court say that it is going to run concurrently. This is a special provision. 428, bacha, it deals with the period of detention which has been undergone by the accused. Section based question is asked from this particular section. Section based question. Then please come to section 432, everybody. Come to section 432. But in section 432, the appropriate government has two powers, either to suspend or to remit. So the two powers only given to the appropriate government. One is suspension, one is remission. But in section 433, the power of commutation has been given. Please come to section 433. The commuting power has been given under section 433. This power has been given to the appropriate government, and remember, this is without the consent of the person sentenced. This can be without the consent of the person. You can commute. Okay, if there is a death sentence, it can be commuted to any punishment given in IPC. If it is a sentence for life, you can commute it to imprisonment for a term not exceeding 14 years. Rigorous imprisonment, change it to simple imprisonment. If it is a simple imprisonment, change it to fine. Okay. Section 433, bacha, A. 433A, it has to be read with section 55A of IPC. Section 55A of IPC. Now we come to the most important provisions, that are the bail and the bail bonds. Chapter 33. Chapter 33, bacha, it deals with the bail and the bail bonds. In 436, section 436, bacha, we are dealing with the bailable offences. Okay. 433, bailable offences are here. On this point, there's a landmark case of Gurcharan Singh versus NCT Delhi. In this particular case, principles regarding the bail provisions were laid down. Gurcharan Singh versus NCT Delhi, the principles were laid down regarding your bail. Now, in 436A, this is dealing with the under trial prisoners. Now, when you speak of the under trial prisoners, bacha, now there is a maximum imprisonment period that has been given, which is 1/2. Okay. Now, if during the period of investigation trial, if the under trial has already gone 1/2 of the imprisonment there, now he shall be released. The word used is shall. But again, notice has to be given to the PP, and the PP here is going to be heard. Okay. Now, 437, bacha, this deals with the cases of non-bailable offences where the bail can be given. Now, this power, it does not lie with the High Court or the Court of Session. It lies with the courts of magistrates only under section 437. The clause 1 and clause 2, bacha, this is to be read together, that he shall not be released if both the cases are saying shall not be. If, he has committed an offense which is punishable with death or imprisonment for life, or this is exceeding 7 years and he has been previously convicted also. Okay, so both the conditions have to be read together. Again, the court is not going to give you bail if the person here is under the age of 16 years, okay, or is a woman, or is a sick, or is a sick person here. Then you have to understand here that the person can be released on bail provided the conditions are getting fulfilled. In section 437 subsection 2, bacha, in this particular case it is any stage of investigation. Okay, so in section 437 subsection 2 we are talking about any stage of investigation, inquiry and trial when the bail can be given. But when you come to section 437 subsection 3, in this particular case the word uses the court shall impose conditions. So if you are giving bail, okay, now let's say there is a person who has been suspected of committing an offense which is exceeding 7 years or any other offense. Remember, bail conditions have to be imposed. On this important point, you have a case of Gurbakh Sibia. So you can understand, all of you, Gurbakh Sibia is a very important case here. But in subsection 4, it is making it clear that it has to be a reasoned order. If you're giving bail, it has to be a reasoned order. The reasons have to be recorded in writing here. In 437 subsection 6, this is a very important provision here. If it is a non-bailable offense and the trial is not concluded within the period of 60 days from the first time the evidence is taken, bacha, now the person can be released on bail. But again, reasons are to be recorded in writing, and this has to be to the satisfaction of the magistrate. In subsection 7, what is happening? The trial has concluded now. Okay, the trial has concluded, non-bailable offense. Before judgment, if the judge feels that okay, now you have to release the person, this particular person can be released on bail. Okay, now 438 bacha deals with your anticipatory bail. Direct question for your exam. 438 anticipatory bail. There are two courts that have the power. It is the High Court and the Court of Session that have the power to give you anticipatory bail. On this point, 438 everybody, 438 deals with anticipatory bail, High Court or the Court of Session. On this point, please remember Sushila Agarwal versus NCT of Delhi 2020. This is a landmark judgment. Sushila Agarwal versus NCT of Delhi 2020. Then please remember in 439 we are dealing with the special powers of the High Court and the Court of Session regarding bail. So in 439 both the courts have been included. Okay. In 440 what is happening? The amount of the bond, once it can be fixed, but it should not be excessive. It can be any amount, but it should not be excessive. This is a very important point. It should not be excessive. Okay. 441A everybody. 441A deals with the declaration by the sureties. This is a very important question. 441A section based question is asked. 441A declaration by the sureties. At the same time, section 444 deals with the discharge of the sureties. 441A declaration by the sureties. 444 deals with the discharge of the sureties. Okay. 446A everybody. Please come to section 446A. Section 446A, bacha, it deals with the cancellation of bail bonds. Cancellation of bail bonds. This is again a prelims question. What is asked in the paper is a section-based question. This is cancellation of bond or bail bonds. Okay. Now, please come to section 449. Come to section 449, everybody. In 449, we are talking about the appeal from orders given under section 446. If it is an order of a magistrate, bacha, the appeal is going to lie to the session judge. If the order is made by the session judge, the appeal is going to lie to the court to which it ordinarily makes an appeal to. Then in 451, bacha, we are talking about the order for the custody and the disposal of the property pending the trial. Okay. On this point, what is important here is section 455. This is, okay, 451 bacha deals with pending trial. 452 deals with the conclusion of the trial when you are disposing of the property. 451 pending trial. 452 conclusion of the trial. Please come to section 455 everybody. 455 bacha deals with the destruction of the libellous or any other material. So direct question is asked, section based question is there. 455 deals with your destruction of libelous or any other matter. 455, direct question is asked, prelims based question is there. In 459, bacha, the power to sell perishable property is given. This is also your prelims question. 459, perishable property, prelims question. 460, bacha, it deals with the irregularities which do not vitiate the proceedings. Okay, so 460, 461 are very important. 460 deals with those irregularities which do not vitiate the proceedings. This particular section requires a thorough reading. 461 deals with the irregularities which vitiate the proceedings. Again, the grounds which are mentioned under section 460 and 461 are very important for your prelims. You can expect one question from this particular section. Okay, 460 and 461. You need to give it a thorough reading, everybody. Now in 463, bacha, we are dealing with the non-compliance here with the provisions of section 164 and 281. Again, a section-based question. Section-based question is asked, bacha. In 464, the question is, what is going to be the effect of the omission to frame the charges or the charges are wrongly framed? Okay, you can give it a reading. Reading is enough for section 464. Please come to the limitation period. Everybody come to section 468. Now 468 is a very important question for your prelims. It says what is going to be the period of limitation. If the offense is punishable with fine only, bacha, it is going to be 6 months. If the offense is punishable for a term not exceeding 1 year, 1 year. If the term offense is punishable with an imprisonment exceeding 1 year, not exceeding 3 years, is going to be 3 years. Okay? This is a very, very, very important question. 469, bacha, it talks about the commencement of the period of limitation. You need to give it a reading. Only reading will suffice here. Please come to section 471. In 471, we are talking about what is going to happen when the court is closed. Okay, let's say the limitation expires on the day when the court is closed. The court may take cognizance on the day when the court reopens. Okay, so this is a section-based question which is normally asked, 471. But a 472 deals with the continuing offenses. Now, this is a very important question here, that whenever you're speaking of the continuing offense, every time the fresh period of limitation is going to run every time when the offense is committed. Okay. Please come to, everybody, please come to section 477. In 477, it is the power of the High Court to make rules. Now, the High Court has the power to make rules here. Okay. Now, this is the section itself is very important. 479, again, section-based question. What are you going to do if the judge or the magistrate is personally interested in any particular case? Okay. Please understand, this particular section is important for your prelims. 479, direct question for your prelims, section-based question is asked from this particular area. And then the most important section is section 482, which talks about the inherent powers of the High Court. Please remember, in section 482, it is the High Court that has the inherent powers. No other court has the powers. It is only the High Court that has the powers. And the 2 pointers which has been given, please remember, to prevent the abuse of the process of any court or to secure the ends of the justice. Okay, total we have 484 sections here. Everybody, 484 sections. The last section is 484 and we have 37 chapters. 37 chapters, 484 sections. And on this point, we end the rapid revision for CRPC. Thank you so much, everybody. I hope this was a fruitful session for all of you. Thank you so much.